Let's go back to the differences between wrongful birth and wrongful life.
Okay.
Now, you have touched on it, but let's expand that further. Had Mrs. H come to you before that 3-year period,
Yes.
what would have happened?
It would have been a claim in her name for the costs of the extra costs of bringing up a child with disabilities. Okay, so that's how we would claim. Yeah.
And that would be perfectly
It's
accepted
recognized.
in South African law.
It's recognized in our law, and there are many cases like that. Yes.
So you're actually pushing for something quite new for
Yes.
South African law.
Well, you know, it has been heard in the Supreme Court of Appeal previously, before the Constitution came into effect, in a matter of Stewart versus Botha. And that the Supreme Court of Appeal then ruled that the sanctity of life is paramount, and they did not feel that that court was able to rule on sort of whether the common law needed to be developed. Okay, so that's a reason why we appealed directly to the Constitutional Court as well, which the respondents also believe is not the way we should have done things. But we argued that at court yesterday as well. But we do think, hopefully, we'll get over that hurdle. Yeah.
Speak to us about the decision then for this all to be heard in the Constitutional Court and not any other court in the country.
Well, the main thing about our case now is that it's post-Constitution. Okay, it's post-Bill of Rights. We have that lined up. We have the most progressive constitution in the world, and that's recognized worldwide. We have the Choice of Termination of Pregnancy Act. It's legislation. It allows a woman to terminate a pregnancy. And we also have this fabulous Children's Act, which protects the interest of children no matter what. So with that, we feel it's perfectly lined up for us to take on, or our law to take on this very, very big step in developing what's our common law. Yeah.
Speak to us about your arguments yesterday. How did it go? How are you feeling about it?
It's, you know, the Constitutional Court, we had 9 judges in front of us, and my senior counsel, Paul Hoffman, stood up, and he wasn't even on his feet for more than 4 seconds before the judges started firing questions at him. So what happens is you file submissions, your heads of argument, where you put your argument, you set your argument out in 50 pages. And we worked tirelessly, many hours a day for quite a while to get that our case really jacked up. And so the judges have that to work from, as well as all the references that we've given them, which is case law, it's international case law, and it's academic articles from the academics in South Africa, as well as academics from all over the world. And most of the academics all over are in favor of this development of the common law.
Now, should you be successful with this claim, would that then set the basis for future rulings in South Africa?
Oh yes, no, this will change law completely. It will now recognize that the person who is the suffering person.
In this case, the child.
Yes. And in all cases of this nature, that the child or the person is suffering as a result of negligence, they can claim. Whereas before that wasn't. The big thing is they say that when the mother went to the fetal assessment center, she was protecting, it was a legal duty that was owed to her. And the respondents are saying it's not a legal duty owed to the fetus at that time. So that's why there cannot be a claim, because the fetus doesn't have those rights. We're saying, how can that be? Especially in this day and age, with in vitro fertilization, with specific genetic testing, with in vitro surgeries that are taking place. We need to also, and our Constitution is the Constitutional Court is very aware that they do need to look into the future, where medical science is going. So it's very important for them to consider those things as well.